Sussex gang, let's pause for a moment. Because after more than 3 years of promises, predictions, legal filings, television appearances, and breathless speculation about Prince Harry's American immigration records, something rather extraordinary has happened. The records were finally processed. And what did the public get? Not 10 pages, not 5 pages, not even one heavily redacted paragraph. The US State Department says it identified now. Let that sink in. For years, we were told that Harry's immigration records could potentially reveal whether he disclosed his past drug use, whether he received special treatment, and whether there was some enormous scandal hiding inside the American immigration system. The suspense was built, the headlines were written, the accusations were repeated, the insinuations were amplified, and now the government has processed its first batch of State Department records. And the grand reveal is, oh, Sussex gang. That is not exactly the blockbuster ending some people were advertising. And it raises a very uncomfortable question, because that is where this story gets fascinating. Let's go back to the beginning. Niall Gardner and the Heritage Foundation have spent years pursuing Prince Harry's immigration records. The argument was presented as one of accountability. Harry wrote about past drug use in Heritage wanted to know whether he disclosed that history during the US immigration process. That sounds straightforward on the surface. But there is an enormous legal question sitting underneath it. Because immigration paperwork isn't a celebrity scrapbook. It contains intensely personal information. And American law has specific confidentiality protections around immigration records. That distinction matters, because you can believe Harry should answer questions about his memoir. You can believe public figures should be accountable. You can even believe the government should be transparent. But none of those beliefs automatically create a legal right for the public to inspect someone's private immigration file. And that appears to be the wall Heritage keeps encountering. Now we arrive at the latest development. According to the August 10 court filing you reference, the State Department made its first interim production on July 30th. It identified 18 responsive records, and withheld every single one. The department cited confidentiality protections under immigration law alongside FOIA exemptions relating to issues including personal privacy and law enforcement information. So here's where we need to be intellectually honest. This filing, it doesn't prove that he lied. It doesn't prove that he told the truth. It doesn't prove that he disclosed every detail. It doesn't prove that he received special treatment. It proves something much narrower, and that distinction is absolutely crucial. Because online commentary can turn records withheld into records of being hidden because they're explosive. But those are two completely different propositions. A record can be withheld because it contains protected personal information. A record can be withheld because Congress created confidentiality protections. A record can be withheld because a FOIA exemption applies. None of those automatically means, and this is where the narrative deserves a little more scrutiny. This isn't even Heritage's first battle over Harry's immigration history. Its earlier lawsuit targeted the Department of Homeland Security after Harry's memoir generated questions about his past drug use. The campaign received enormous media attention. By March 2025, you could easily have gotten the impression that Harry's immigration records were finally about to be dragged into daylight. But that wasn't what happened. Previously sealed court material was released. There were pages and transcripts. There were redactions, there were arguments, there were declarations, but Harry's underlying immigration records remained private, And perhaps most importantly, one government declaration pushed back against the suggestion that Heritage had uncovered evidence of preferential treatment. USCIS official Jared Panter characterized the preferential treatment suggestion as speculation and pointed to a lack of evidence of government misconduct. That matters, because there's a huge difference between saying and saying questions can justify investigation. They don't justify pretending the answer has already been established. And after years of this campaign, the public still hasn't been presented with evidence showing that Prince Harry received preferential immigration treatment. That's the part that deserves far more attention. And then there is the privacy argument. Imagine this happened to an ordinary American. Imagine someone publicly discussing their private immigration records because they had written a memoir containing controversial personal information. Would we automatically say, well, they're famous, so hand over the file? Probably not. Privacy doesn't evaporate simply because somebody becomes famous, and Prince Harry's celebrity status doesn't automatically eliminate statutory protections over his immigration records. In fact, the government's concern about harassment and unwanted contact becomes particularly interesting when you consider the extraordinary level of public attention surrounding this campaign. The more intensely the public hunts for someone's private records, the stronger the argument becomes that disclosure could have real consequences. That doesn't mean governments should be allowed to hide misconduct, absolutely not. But it does mean the burden is on those demanding disclosure to establish a legitimate legal basis for getting around confidentiality protections. And so far, the biggest public revelation from this latest State Department development isn't some secret immigration confession. It's the existence of "That's a very different" headline. Now let's talk about the part that gives this story its real sass. Because Niall Gardiner has been one of the most visible advocates of this campaign. He has repeatedly framed the matter around accountability and transparency. And after the earlier release of heavily redacted material, he criticized the process and argued that Americans deserved answers about whether Harry had been truthful regarding his past drug use. Fair enough. If transparency is the principle, then transparency should be the principle regardless of whether the latest development helps your preferred narrative. And that's why the latest filing creates such an interesting contrast. The State Department has now identified 18 responsive records. All 18 were withheld in full. Yet, based on the material you've provided, there hasn't been a comparable public explosion from Gardner about this particular development. No dramatic countdown, no "the bombshell is coming", no celebration of transparency, because, frankly, there isn't much to celebrate when the public has received an Sussex gang, I have to say. That's where the irony becomes almost delicious. For years, the campaign has been asking, but the government has effectively answered, and that isn't the same thing as... Now, let's be careful here. I'm not going to make the same mistake that some commentators have made. The withholding of the documents does prove Harry's immigration story was completely clean. But equally, it does prove that he committed immigration fraud. That's the intellectually honest position. We don't know what's inside those 18 records, and precisely because we don't know, nobody should be filling that vacuum with their favourite conspiracy. If Heritage eventually obtains additional material through litigation, then let's examine it. If a court orders disclosure, let's read what is released. If credible evidence of misconduct ever emerges, let's discuss it. But until then, the responsible conclusion is remarkably simple, and that distinction should matter. Because if you spend 3 years telling an audience that the evidence is coming, eventually people are entitled to ask, where is it? Perhaps the most revealing part of this entire saga isn't Prince Harry's immigration paperwork at all. Perhaps it's what happens when speculation becomes a media narrative powerful enough to create its own momentum. One legal filing becomes a headline. A request for records becomes Harry's visa nightmare. A question about disclosure becomes an insinuation of deception. An attempt to obtain documents becomes a countdown to a bombshell. And then the documents arrive, and they're withheld. Suddenly, the absence of evidence doesn't end the story. It simply creates another round of speculation. That's how you can end up with a story where the thing being investigated becomes less important than the investigation itself. And that is precisely why we need to keep our heads. Because Sussex gang, we don't have to defend Harry by pretending we know what's inside documents we haven't seen. We defend the truth by demanding that that's a much stronger position. So here's my question for the Heritage Foundation. If the ultimate goal is genuinely accountability and transparency, what happens when the law says the records are confidential? Do you accept the legal framework? Do you challenge it through the courts? Do you produce evidence of actual government misconduct? Or do you simply keep suggesting that something explosive must be hiding behind the redactions? Because those are very different approaches. And if the case is really about equal treatment under American immigration law, then the strongest argument would not be, it would be. But without that evidence, the entire argument risks becoming circular. We need the records to prove misconduct. Why do you think there's misconduct? Because we need the records. That isn't proof. That's suspicion-chasing documentation. And after 3 years, Sussex gang, suspicion is still not evidence. So where does that leave us? After all the noise, after all the headlines, after the legal battles, after the speculation? The State Department's first production gives us 18 responsive records, and the public gets... Now, somebody somewhere will undoubtedly interpret that as proof that Harry is hiding something. But let's reverse the logic. If the government had released the records and they contained evidence of misconduct, then yes, that would be significant. If the government released records showing no misconduct, that would also be significant. But when the government withholds records because it says the law protects them, the only responsible conclusion is that, and honestly, that's a little awkward for a campaign that has spent years encouraging everyone to believe that the next filing would finally crack the case wide open. Because the great Harry immigration treasure hunt has so far produced an awful lot of legal paperwork and remarkably little actual evidence. So, Sussex gang, here's where I stand. Question Harry. Question Meghan. Question the government. Question the media. Question heritage. Question everybody. But apply the same standard to everyone. That's what fairness looks like. If there is evidence, show it. If there is misconduct, prove it. If there is a legal violation, establish it. But don't turn a protected private immigration record into a blank canvas onto which everyone can paint their favourite scandal. Because right now, after all the anticipation, the biggest headline isn't "it is." And that is not the bombshell. That's the lack of a bombshell. So tell me in the comments. And most importantly, should the same standard of evidence apply to Harry as it does to everyone else? Let me know what you think. If you enjoyed this breakdown, hit that subscribe button, turn on notifications, and join us for the next deep dive. Because here we don't need to manufacture a scandal. And sometimes the most revealing receipt is the one that says, "Until next time, Sussex gang. Stay sharp, stay skeptical, and never let somebody else's speculation become your evidence."